Welcome to the LLG Grapevine podcast. You're listening to Dennis Hall, LLG Bulletin Editor, and joining me this week is Kieran McGaughey, Membership Director and Procurement National Lead.
Hello, everyone.
Well, this week has seen the controversies centred on 10 Downing Street simply multiply. Commentators are asking, well, what impact does all this have on policy making? And what about levelling up? It is now over 2 years since the government flagship concept of levelling up was first announced by the government. Since then, we've had no firm policy plans. England's north-south divide continues to deepen despite 2 years of rhetoric from the government, according to a landmark new report published last week. Entitled State of the North 2021 and produced by IPPR North, the report compares levels of public investment in London and the South East with that in the North. Its authors estimate that in the 5 years to 2020, London received the equivalent of £12,000 per person, while in the North the figure was only £8,000. Treasury data indicated that if investment in the North had matched that in London over the 5 years from 2015, it would have meant an extra £61 billion of spending in areas such as transport, infrastructure and skills. The stark disparities will fuel concerns in our sector that the government's flagship policy is underfunded and does not fulfil the government's promise to rebalance the economy. In November, the promised eastern leg of HS2 from Birmingham to Leeds was scrapped, and a proposed high-speed line between Manchester and Leeds downgraded. This was taken as a sign that the government commitment to this rebalancing is not solid. Now, the Levelling Up white paper detailing the government's plans has been repeatedly delayed. It is now due by the end of the month. Let's wait and see.
Thank you, Dennis. So the Police Crime Sentencing and Courts Bill has continued to receive scrutiny during its report stage in the House of Lords. The government has suffered a series of defeats in the House of Lords over its plans to clamp down on disruptive and noisy protesters after opposition peers voted against a range of measures. Peers also voted to make misogyny a hate crime in England and Wales in another government defeat. That said, a number of government amendments were agreed, including ones which will ensure that the provisions around serious violence reduction orders can only be commenced once a report on the pilot has been laid before Parliament and both houses have voted on it. An amendment tabled by Lord Coker, which allows fast-track public spaces protection orders to come into effect immediately to protect schools and vaccination centres from anti-vaccination protests, was also agreed. If this amendment is passed, we would expect appropriate guidance to be issued to ensure councils have appropriate guidance on how to use this new power. So, Dennis, whilst normally my area of law and a topic very close to my heart, I understand you've been looking at the latest case law on government procurements during the pandemic. What can we learn from those, Dennis?
Yet another case against the government, launched by the Good Law Project, has shown the government approach to procurement during the pandemic to be inadequate. The latest in a line of cases which came before Mr. Justice Farrell covered a number of general principles, including those in relation to equal treatment and transparency. So, what are the key principles that apply to all contracting authorities? A contracting authority must always adopt ground rules setting out the procedure for procurement, the conditions that must be met by any tenderers, and the criteria by which any award will be made. The rules must be advertised and sufficiently clear so that any interested contractor may take the decision to tender for the contract, fully understanding the significance and weighting to be applied, and so they can interpret the rules in the same way. It was noted that contracting authorities are afforded a wide margin of discretion in designing and setting award criteria. A contracting authority is not permitted to change any of the essential conditions of award criteria during the procurement process without making a formal amendment that is publicised to all potential tenderers. And finally, when assessing tenders, a contracting authority must apply the award criteria uniformly to similar bids, unless there is an objective justification for a different approach.
Another interesting case for procurement lawyers, Dennis. So, taken from the Parliamentary Bulletin, the Local Government Disqualification Bill had its report stage and third reading in the Commons last week MPs were briefed ahead of the debate, where the LGA highlighted its support for the bill, agreeing that individuals convicted of the sexual offences outlined in the bill should be disqualified from running for public office or retaining their seat if already elected. However, the LGA are clear that it is not right that these proposals apply only to councillors, mayors and assembly members. Police and crime commissioners and members of the House of Commons and House of Lords must equally be disqualified from public office. During the debate, Sir Christopher Chope MP spoke on the amendments which he had tabled. In the LGA briefing, they highlight that they do not support amendments NC1 and NC2, which would add a broader range of potentially minor and historic offences to the councillor disqualification criteria. If accepted, those amendments would be disproportionate and would preclude individuals who had already paid their debt to society, potentially decades previously, from giving back to their communities by becoming a local councillor. All of the amendments were withdrawn and the bill passed without amendment. It will now head to the House of Lords for its second reading. Something else continuing to gain a lot of attention at the moment is the issue of local authority decision-making meetings and their inability to meet virtually. Dennis, what have you heard about the cost of council meetings because they cannot meet remotely?
I was interested in the BBC news item about the cost of compliance with the COVID rules in arranging in-person council meetings. Last week, Rotherham's council leader said he believed that in-person meetings were unnecessary, with high COVID rates throughout the borough. Moreover, holding COVID-compliant council meetings in Rotherham has cost more than £29,000 since last summer. Legislation allowing meetings to be held remotely expired, of course, in May, meaning that councils have had to use or hire large venues to allow for social distancing. Since then, 4 full council meetings have been held by the council at various locations around the borough. But holding meetings away from the local authority's council chamber has involved enormous cost. Earlier this week, council leader Chris Reid called for a return to virtual meetings amid spiralling numbers of COVID cases in the borough. LLG and ADSO, along with just about everyone else in the sector, fully support giving councils the right to conduct remote meetings. And don't forget to sign that petition in support of this. The details are in Bulletin 2. A spokesperson said the department would be responding shortly to evidence submitted regarding a longer-term decision on whether to allow councils to meet remotely on a permanent basis.
Yes, thank you, Dennis. The petition is available on change.org and it's generating more votes every day. I've signed, and I would personally encourage all of our members and all of your contacts within local government to sign the petition as we continue to apply pressure to enable online provision. Now, England's Plan B COVID measures are to end from this Thursday, with mandatory face coverings in public places and COVID-19 passes both being dropped. The Prime Minister also said the government would immediately drop its advice for people to work from home. In consequence, civil servants were told to get back to their offices to set an example, with the Prime Minister stating that across Whitehall we need to show a lead and make sure that we get back to work. In education, however, it has been reported that some schools will keep a mandate to wear masks despite the easing of restrictions. The National Education Union, which represents teachers, called the removal of masks in secondary school classrooms premature. Even more concerning, Dame Rachel de Souza, the Children's Commissioner for England, has said that thousands of children have fallen off the radar during the pandemic, as she launched an inquiry to track down youngsters who are not in the classroom, saying that one of the problems with there is no national database of children who aren't on the school roll.
Well, thanks for that one, Kieran. And that's it from us this week. You can get much more on these items by going to Bulletin 3, available via your inbox or by signing up to our new website. But for now, it's goodbye from me.
And it's goodbye from me. Thank you for listening, everyone, and I hope you have a great week.